5 seconds to go. Start. Mr. Mehta would submit that the 5 FIRs referred to above, registered against the respondent accused prior to the 2015 Act coming into force, were sufficient to bring the case within the ambit of continuing unlawful activity as defined under the 2015 Act. Stop. He would submit that the term organized crime as defined under section 21E of the 2015 Act uses the term continuing unlawful activity. Stop. A bare perusal of the definition of the term continuing unlawful activity would indicate that it does not refer to any continuing unlawful activity to be committed only after the promulgation of the 2015 Act. Stop. Mr. Mehta would argue that the said term means activities prohibited by law in respect of which more than one charge sheet has been filed before a competent court within the preceding period of 10 years. Stop. The phrase within the preceding period of 10 years by itself indicates that the continuing unlawful activity may be such activity, which could be said to have been committed prior to the enactment of the 2015 Act. Stop. Para. Mr. Mehta submitted that one distinguishing feature of the decision of this court in the case of Shiva alias Shivaji Supra is that in the said case, the accused persons were acquitted and the same signified that way were not involved in the commission of the offence with which they were charged. Stop. It is in such factual background that this court in Shiva alias Shivaji Supra could be said to have observed that it is only if an organized crime is committed by the accused after the promulgation of Maharashtra Control of Organized Crime Act, 1999 for short, the Makoka, that he may, seen in the light of the previous charge sheets and the cognizance taken by the competent court, be said to have committed an offence under section 3 of the Makoka. Stop. Para. In the last, Mr. Mehta submitted that if the dictum as said in Shiva alias Shivaji Supra is affirmed, the object of the 2015 Act, that is, Prevention and Control of Terrorist Acts and for coping with criminal activities by organized crime syndicates, will surely get hampered. Stop. Para. In the aforesaid contest, the submission of Mr. Mehta is that if, the dictum as laid in Shiva alias Shivaji Supra is to be treated as the final word so far as the law is concerned, then the first case under the 2015 Act can be registered, only after two cases of the nature described in the 2015 Act, had been registered against the person or against an organized syndicate after 1st December 2019. Stop. As the definition indicates, for making a crime punishable under the provisions of the 2015 Act, there has to be more than one case registered, or in other words, it is the third case which can be registered for an offence under sections 3 and 4 respectively of the 2015 Act. Stop. Such an interpretation would be in direct conflict with the very purpose of the 2015 Act. Stop. If such an interpretation is accepted, then the state will have to wait and helplessly watch the organized crime taking place till it is the third time a person or a syndicate is found involved in the offence after the 2015 Act came into operation with effect from 1st December 2019 in the state of Gujarat. Stop. According to Mr. Mehta, the continuing unlawful assembly could have taken place 10 years prior to the registration of the new case. Stop.